just telling me bye. She's heading out. Um, yeah. How are you today? I think we had this brief chat about how our days have been going, and Joseph has shared that been a bit chaotic, just
Yeah,
the
well, no,
latter
no,
half.
So this is the
yeah,
opportunity to relax right now. Right now is the opportunity
Yes.
to chill
exactly.
and let the audience be educated a little bit more.
Yeah.
For
We're
sure.
just having
Hopefully
a
learn a couple
chat.
things.
So it's 5 o'clock now. Might as well just get going. So today's topic is what the judicial system values in parents. Another helpful topic that I think a lot of our viewers and listeners will appreciate. I would like to start with a disclaimer. Please note that the purpose of this series is to discuss general information on separation, divorce, and family law matters. Any information provided here should not be construed as legal advice. Please use the Q&A function if you have questions or comments that you would like to submit throughout the within this time that you have with us. And if you have questions regarding your specific matter, it would be best to call a law office or a lawyer in your area. You can call our office. That's also an option to book a consultation to receive tailored advice. And then at the end of all of this, we're going to be sharing how you can schedule a free 20-minute initial consult with one of our lawyers. So stay tuned for that. Okay, so I think I'll start with the bios. I'll just get my intro out of the way. I'm Jodine. I'm an articling student. I'm still learning a lot here at RIA and within family law more generally. So I also learned a fair bit from these sessions as well. I'm really excited to have Joseph and Golan here. I'll do their intros as well. Joseph is a compassionate family lawyer driven by a deep desire to support families through challenging times. With a background in commerce, he brings a strong negotiation, analytical, and critical thinking skills to his legal practice. During his articling period, he gained confidence in handling a wide range of family law matters. Joseph emphasizes active listening, clear communication, empathy, and fostering a comfortable environment for his clients. He is a certified collaborative lawyer with the Ontario Association of Collaborative Professionals and thus offers clients a an alternative dispute resolution approach to avoid court. Outside of work, Joseph is say it with me, Joseph, a dedicated,
Toronto Maple Leafs fan. And I mean, it was a
okay.
close game yesterday. It was a close game yesterday, so I'll take the 1 point in overtime
Oh,
loss or a shootout loss.
yay, hockey. So next with us we have Golan Yaron. He is a family law associate here at RIA. He is a certified mediator with over 25 years of legal experience. Golan, what? But you're so young. Um, he was first called to the
I'm not
bar.
dyeing my hair.
Okay, no, really? Oh, good for you. He was first called to the bar in Israel in 1996 and then called to the bar in Toronto, in Ontario, sorry, in 2003. Golan has extensive experience in representing clients and negotiation agreements as well as trial work. He also has experience in negotiating with the authorities to advance a client's interest and has represented clients at various levels of court, including on appeals. And Golan has a wealth of knowledge in both family and criminal law matters. Yeah, he's a bright spark. So let us dive right into our discussion, unless you guys want to say anything else about yourselves. Golan, do you have a cool tidbit like Joseph does?
Thank you for the kind words and the introduction. It's always there's always something to learn even after 25 years in the profession. And that's the reason that, right off the bat, I can say that the most appreciating thing that the court can divulge in terms of parents is not showing up in court, not starting the proceedings at all. That would be the most appreciated gesture that we can consider if parents manage to stay out of court and in alternative resolutions such as the one that Joseph is trained in and able to provide a collaborative setting that would assist parents to resolve matters in a more relaxed, I would say, settings and more comfortable and collaborating style.
Is something we at Russell Alexander Family Lawyers, collaborative family lawyers, believe in very much. And yeah, we've had quite a few sessions on just different ADR methods, so alternative dispute resolution methods that keep clients out of courts. And we'll gladly have you revisit those after hours videos. You can find them online. So sorry, my AirPods just died. Can you hear me?
Yeah, we can.
I will fix that. So let's start by addressing one of the biggest concerns parents might have when they enter the legal system is parenting time and decision making. How about that? So many parents will come into litigation seeking sole decision making because that's, they want to win. They want to have the one-up, or if sometimes they might come in seeking joint decision-making responsibilities, but in reality, their primary concern is staying involved in the child's life. So it's important for us to clarify the legal principles of parenting time and decision-making, distinguish those two. So because sometimes, we come in with the wrong language, thinking that they're asking for sole decision making or sole custody, which is a term we don't use anymore. So decision making responsibilities refer to major life decisions for the child, things like education, healthcare, and religion, so on. It's listed in the legislation. Parenting time, on the other hand, determines where the child resides, how much time they spend with each parent. And so these are separate legal concepts. It's important to clarify that these are whether or not the parents actually have goals in mind that relate to decision making versus parenting time, because those terms get mixed up a lot. So yeah, you right off the bat, you need to clarify your desired interests, what you want out of the family law process, and knowing the distinction between parenting time and decision making is an important first step to know what you're asking for. Also, understanding what sole decision making is, joint decision making, parallel parenting. There's going to be a lot of terms that come up, and this is something that you should definitely address with a lawyer if you retain one, understanding what the difference is in in those arrangements are, and then understanding what you want out of this process. So, but ultimately, courts favor arrangements that promote ongoing parental involvement while minimizing the stress for the child. So you need to bear that in mind as well. Golan, I don't know if you have anything to add on that. I know you have experience, and you, Joseph, too, in unrealistic demands or from parents.
I'll be happy to, firstly, the idea of, you said correctly that parents have to differentiate between the two concepts of parenting time and decision-making responsibility. But that comes down to personalities, and the fact that there was a breakdown of a marriage or relationship causes one parent to think, oh, I was the primary caregiver, I should be the only one making the decision, etc. At the end of the day, the appreciation is to those parents who prioritize the interest of the child in that respect, and actually see beyond that egocentric approach of I'm a better parent and I can do better and I should be making the decisions. Similarly, when it comes to the spending time with the other parent, and that encouragement to ensure the involvement of both parents. Again, everything is subject to practicality, assuming things are generally normal, other than the fact that there was a breakdown of the relationship. Obviously, that's something that takes time to subside until maybe the resentment and other aspect of the breakdown are kind of not leading the thought process. And that's the important thing here, is that when people understand what is involved in the decision-making process, and why should I make the effort to collaborate, or to have some cooperation with the other parent when it comes to major decision in a child's life. It's that would be a big step forward in a resolution of many other things that comes along in the proceedings, and may come up as part of the raising of a child. I mean, even in a solid family unit, you may have a situation where when the parents do not agree. So let alone when the parents are separated
In
and
conflict, yeah.
in conflict constantly,
Mhm.
and depending on the tension that exists at the time of separation and following. So in that respect, prioritizing the best interest of the child is, shows a lot of maturity, a lot of understanding of what's more important.
For
That's
sure. And
in a nutshell.
thank you, Golan. Appreciate that. And that's brings us neatly into our next topic, which Joe will talk about, which is best interests of the child.
Yeah, thanks, Jody. So with respects to prioritizing the best interest of the child, oftentimes that term is tossed around quite frequently, especially in my practice. And the response I get from clients in return is, what does best interest of the child actually mean? Parents typically have their own subjective views of what the best interests of the child are, and I mean that's normal, that's realistic. Each parent is going to have their own subjective views on what the best interests of the child are, and more often than not, it's going to be tied into what is in their best interests. At the end of the day, this test is supposed to be done on an objective basis, and that's how the courts tend to look at this. They look at it from an objective lens, not a subjective one. So with respects to the best interest of the child and what exactly that means, it is the foundational principle in Ontario family law, and quite frankly, family law across the country, and it guides all parenting and relocation decisions. The best interest of the child ensures that court rulings prioritize the child's physical, emotional, and psychological well-being. And the test is actually outlined in both the Ontario Children's Law Reform Act as well as the Divorce Act, which is our federal nationwide legislation. And there's various key factors that the courts use or I should say, that they consider when they are guiding their decisions as it relates to parenting. The first most common one that they look at is emotional ties. So they look at the strength of the child's bond with each parent, their siblings, as well as the extended family. They look at routine and stability. So if whether or not there is a preference for maintaining consistency in schooling, community involvement, and living arrangements. They also look at parental capacity. So that's the ability to be able to provide for the child's needs, including emotional support, education, healthcare, and overall development and well-being of the child. They look at the child's preferences, and these are taken into account if the child is mature enough to express a reasonable preference. More often than not, this will also be done through what's called a Section 112 assessment or a Voice of the Child report. There's also a Section 38 assessment, in which that is a private, non-governmental assessment that's done where they ascertain the child's preferences that way as well. They also look at the history of care. So the courts look at which parent has historically been the child's primary caregiver, who is responsible for making the lunches, who is responsible for getting the child to and from school or to and from daycare, who took the child to the medical and dental appointments, who took them to their extracurricular activities. All these things are considered. And finally, another key factor that's considered by the courts is if there's been a history of domestic violence, if there's been a history of neglect, if Children's Aid Society has been called, and whether or not they have maybe commenced child protection proceedings, whether or not they have verified concerns. And courts will assess whether a parent's behavior has been harmful to the child. In terms of, practical steps for parents to engage in, as they're going through this process, it's really important that they ensure stability. So being able, as Golan said, being able to minimize disruptions by maintaining school, extracurricular activities, and consistent routines is definitely optimal. Being able to encourage emotional security, so be available, be present, and be responsive to your child's emotional needs. Another key one is fostering strong relationships, which means that you are still actively encouraging a connection with both parents, extended family, and important figures in the child's life. You're not withholding the child, you're not alienating. These are really important things that you should not be engaged in. And finally, being able to demonstrate responsible decision-making or even joint decision-making as a whole, right? Being able to make choices based on what benefits the child rather than personal grievances or what maybe is necessarily in your best interest as a parent. What can hurt a parent's case when looking at the best interest of the child? Exposing children to ongoing conflict. Judges do not appreciate that in the slightest, and they will be very vocal in their displeasement of that. Interfering with the child's relationship with the other parent. So again, engaging in alienating behaviors. A judge will be quite vocal in disapproving of those behaviors. Ignoring the child's emotional needs or well-being. So again, putting their best interests second to your own will look negatively upon you from a judge's perspective. And if there are any interim parenting plans or schedules in place, failing to adhere to those it doesn't look great on you. So in terms with prioritizing the best interest of the child, all of these things that I've discussed all go hand in hand, quite frankly, and what judges look for.
Thank you,
You can
Joe.
see how complex the topic is and how many factors go into play when assessing a best interest scenario. At the end of the day, the parents, you give them a lot of credit in knowing what's best for the child. The idea, though, is that you're not going to write off the opinion or the suggestions that comes from the other parent, as long as it goes to the when you look at extracurricular activities, for example, if the child is an athlete and goes into a rep sports team, and all of a sudden another parent just wants to relocate without consideration of what the effect on that child socially, whether he's going to be disconnecting with this team or friends or classmates. All of this can come into play in looking at what was the drive, beyond the decision to make any sort of a decision, whether it's to relocate or whether it's to transfer school or whether it's to decide to pull the child out of one extracurricular to another, and or prevent a child from engaging in a program that he might have had an interest in, or was thriving in that environment. So all of these things have to be looked at when you're making decision, and when the court comes to judge that decision making of yours. That's where you look at. I mean, at the end of the day, everybody's, the courts and the judges are just as human as the rest of us, and they have perhaps their own life experience in raising their own children and looking at the many parents and dysfunctional families overall. So, at the end of the day, when parents are using the child just as a pawn in a play, trying to win or leverage towards other unrelated matters, that's the key problem. That's where the issues becomes more complicated. One of the tools that Joe, you mentioned before, was a private assessment or voice of the child to try to ascertain some of the preferences or wishes of a child. The engagement of the Office of the Children's Lawyer at times is necessary to get that objective view and best interest, and bring it before the court for assessment. That investigation includes, speaking to pediatrician, to teachers, to social workers, to anybody and anyone that has any contact with the child or may be able to shed some light about what are the child's needs emotionally, physically, etc. So there are tools, and it can also be done in a private assessment to get the same effect. Normally, it just costs way more, but it does sometimes provide the assessment much earlier and in a timely fashion that sometimes is lacking when engaging public source resources. So,
or if you get their involvement at all, right? They don't have to accept. They don't have to
they
accept
don't. It's up to them,
right.
really. Yeah.
So that's a prerogative that they maintain, and again, this is part of public resources that are scarce and need to be prioritized, and they do their own prioritization of cases that may require their attention, and others that
Not so much.
bad or just.
And so I think also what we're getting from this is that the court isn't just simply going to take the parent's word for what is in the best interest of the child. Yes, that is an important consideration, but there are many other considerations as well. And so it's a really can be a complex process in determining what the best interest of the child is, but also important for parents to ensure that any suggestion or claim that they're putting towards before the court is framed in the best interest of the child. So I think our next topic is to you, Golan, and it would be about parenting contributions. And so how would parents frame their contributions? How would the court want to see that?
Well, it relates to all the aspects that we mentioned earlier. So if the child is going to extracurricular activities or is being introduced to one, you want to show the communication with the other parent, the effective consultation, the payments that were made, looking at the finance aspect of things. If the kid require medical attention of any sort, then you want to show the attention to that aspect, the appointments, the consultation again with the other parent. At the end of the day, assuming that there is no verbal communication, which is at times the best, but it's not helpful when you come to court and you want to show the involvement of a parent, because then it becomes just a he said and she said type situation. The maintaining of a written record of exchange of emails, text, and and correspondence that shows that effective communication in a civil manner, to advance the child's interests. That's what really it's hard to argue with when it's there in writing in black and white and in a civil it doesn't reflect badly on the communicating parent, and showing the efforts that are being made in the involvement of the other parent, in the consideration of factors that may change the decision. These type of things are the things that you want to keep in mind when you want to prove to the court your involvement in the upbringing of a child, in the decision making over the years, in the in the communication that you had with the teachers or with other professionals. That's the type of thing that you want to document and make sure that you have it ready to produce if it comes to that. Hopefully you don't have to think about it during your relationship. You're not thinking about how am I going to prove my involvement in my separation. It's really the following that separation is when you have to be more mindful of of showing in a more objective way how the efforts have been made and how the communication is established, and the effectiveness of such engagement of the other side.
For sure. And writing things down is always good for reference. So it's helpful throughout the parenting process more generally, I should guess. So Golan, if you could just expand a bit more on how maybe a parent can showcase stability, security, emotional support, and active involvement in a child's life. Because I find that when I'm writing applications, one of the main things is that you have to show some kind of relationship with the child. You can't just become like, you can't leave that part blank. You have to establish that there's some relationship with the child.
Right. And then when a parent, claims I was the primary caregiver, or I was
Right.
I have such a strong bond with the child. And this is where just saying the words is not sufficient.
Not enough. Yeah.
In the activities that you participated in maybe you were the coach of the kid in hockey or in basketball, or you were an instructor, or you were coming as a parent to all the lunches and preparing and assisting in school, or taking the child to the appointments, and all kind of assessments, and whether it's medical or others. These are the the examples or the instances that a parent would show the involvement with the child, you know, the strength of the bond that has been created with the child is a result of the time that parent spent actively being with that child, whether it's as a spectator or whether it's as a coach or whether it's as a just a parent that listens to what the kid had done that day in school. But all of that is the type of a activities that you would want to describe. And obviously, if you have that references to a to the school activities, to the extracurricular activities, to anything that you were doing with the child, that would be the strongest evidence to suggest the how you were encouraging and supporting the child's well-being overall, um, and provided him with the security and the emotional
Emotional
strength
support.
that
Mhm.
child's need, especially at the early stages and as they grow. Yeah.
Yeah. Joseph, is there anything you wanted to add to that?
No, I think, Golan hit the nail on the head. What I will say is that oftentimes, and I know you brought it up in your introduction, but parents, when they come to me, they more often than not, they want to be, I want sole decision making responsibility. I want limited parenting time. A lot of these unrealistic expectations, or instructions or direction based on what they feel has transpired throughout the relationship, whether they believe that they were the primary caregiver, and, as a result of that, they feel as though they're entitled to, sole decision-making responsibility.
Mhm.
I mean, more often than not, judges will, even if the evidence is there, and I mean, as long as there is communication between the parties, and historically, there has not been a real breakdown in the communication between the two of you. Very, very rarely, again, unless there's extreme circumstances, will a judge award sole decision-making responsibility. And then often, I don't know if Golan, if you have this experience, or Jodine, if you have this experience as well, is trying to get clients to realize that. It's very difficult to ascertain and get relief for sole decision-making responsibility and parenting time based on the terms that your client wants, especially if there's been no history of Children's Aid Society involvement, no history of drug or alcohol use in the home. So, I mean, I think it's really important that, yes, parents should be documenting their contributions throughout the relationship and throughout the marriage, or throughout their common law history between one another, and if they have children. But to be
Mhm.
mindful that at the end of the day, as Golan mentioned, a judge is going to look what's in front of them, and they're going to really take into consideration, will this child be better off if both parents have a say in decision making or not? And
Mhm.
more oftentimes they tend to lean that way.
Yeah, exactly. It's the court is hesitant to award sole decision making absent of the things that you mentioned, Joe, that would essentially create a situation that is not ideal for the child. Um, and so yeah, so yeah, sole decision making is a tough hill to climb. If that's what you're seeking, and it does require some sufficient evidentiary evidence. Uh, uh, Joe, I believe you are up next. Could you please tell us about what obligations the client or the parents have to comply with court orders, and and agreements, and maybe what might be the consequences of not doing that? Why you would have want to avoid not doing that?
No, for sure, for sure. Thanks, Joe. So, with respects to court orders and legal agreements, excuse me, court orders and signed agreements, whether that be separation agreements, parenting plans, both of them usually considered domestic contracts by way of the Family Law Act, are legally binding. As such, parents must strictly follow any terms related to decision-making responsibility, parenting time, child and spouse support, financial disclosure, division of property, any of those terms that are within the court order or the signed agreement must be adhered to, right? The court order is what it is. It is a court order. You are bound by the law to follow that. With respects to, signed agreements as it relates to separation agreements, parenting plans, prenups, all of those are contracts and are deemed domestic contracts by way of the Family Law Act. Those are legally binding. The same way you sign a contract with a service provider for your phone, and you have to follow their terms and compliance, the same way in which you have to be following the terms outlined in these signed agreements. Ignoring your legal obligations can lead to very serious consequences, right? What I've seen throughout my practice, and I've noted some common mistakes that parents make, they'll withhold parenting time, right? They'll deny parenting time to one parent due to unpaid child support not being followed. So maybe one parent hasn't been paying child support, or they're late by a week, or they're late by a month, and the other parent thinks it's within their right to withhold parenting time. That is not okay. When we're looking at, issues that need to be dealt with, they need to be looked at separately, right? I know you often hear from your parents or from anyone else who's ever told you two wrongs don't make a right. And in the legal sphere, that is entirely true. And legal issues, more often than not, are not looked at congruently as in together. Rather, they're looked at separately. So if one parent is frustrating or is not complying with a legal order, that does not give you the right to also frustrate the order and not comply with that order. You have a legal obligation to follow the order. Another one that I see as common mistakes that parents make are failure to pay child or spousal support, right? So courts can enforce payments through wage garnishment, license suspension, or other legal action. These are things that are done through the Family Responsibility Office. So if there is a court order for child support and you are not following it, FRO will take charge and they will enforce that order. More often than not, if you have a separation agreement where child support or spousal support needs to be paid and the payor is not making those payments on a timely fashion or in the amount specified, pending any clauses or any terms in the agreement stating otherwise, that agreement can be filed with the court, and that too agreement can be enforced by FRO. And FRO takes measures, as I mentioned, wage garnishment. They will commence a refraining motion to suspend your license. Rarely, but it does happen. A payor can be serve a jail sentence as a result. So there's a lot of serious legal consequences that can result. Another common mistake parents make is unilateral decision making. So maybe they're making major decisions. Maybe they're moving with the child. They're unilaterally changing the child's school. They're making medical choices without the other parent's input, especially if this is a joint decision making. It's been outlined joint decision making. It's been ordered joint decision making. You have a legal responsibility to jointly make these decisions with the other parent. More often than not, there will be terms to suggest that the other parent's input is still needed and they should still be notified of any of these decisions that are being made. So for example, if one parent does have sole decision making, more often than not, even within a court order or within the signed agreement, it'll be noted that notice needs to be provided. So if you're not complying with that, that's another issue that needs to be flagged. Another one that I often get, quite frankly, is parties ignoring financial disclosure requests. So, hiding assets or refusing to provide financial documentation can lead to contempt of court, especially if it's been ordered by a judge. And if you are actively withholding that financial disclosure, a judge will throw the hammer at you.
Yeah.
And the question I always get from clients, what happens if I don't comply? What happens if I choose to forego the court order, or I choose to forego the signed agreement that, my wife and I or my spouse and I signed a couple months ago? So again, the court can enforce orders through a number of ways. More often than not, they can do this through contempt proceedings. So the other parent or other party can bring either we call them a Section 1(8) motion, so that would be compelling compliance, or they can bring various other motions or contempt motion. They can be seeking fines, they can be seeking um, sometimes even I've rarely seen jail time in extreme cases, but more often than not it deals with either fines or specific performance, which means that they're compelling them to comply with the order. Again, other means in which FRO can actually enforce these orders and what results if you do not comply. Like I said, wage garnishment, license suspension, and sometimes a court can even note that there needs to be a change to the parenting time, despite what's already been listed in the court order or the signed agreements, right? So failure to actually follow the parenting time schedule may result in reduced time, or in sometimes cases, I've seen supervised parenting time as a result for non-compliance of these orders. So in terms of, best practices that I tell my clients on an ongoing basis, it's really important to keep records. So maintain copies of payments that you've made for child and spousal support. Make sure that it's being done via e-transfer. Cash is not something that's that you can follow the transaction history on it. So make sure that you're either doing a bank draft, a certified check, or an e-transfer. Communication, again, it's very recommended, very highly recommended that all communication should be done in writing, whether that's via email, via text message. Sometimes parents are enrolled in a parenting app like AppClose or Our Family Wizard or Talking Parents. Communication through that is also essential, and keep records of the agreements themselves. Make sure you have a copy of the agreement. It's really important that you're not discarding your copy of the agreement. With respects to addressing concerns, I always advise that these concerns are done through legal channels, right? So, for example, if a court order needs to be modified, apply for a motion to change, right? Bring a motion to change rather than violating it. It doesn't look good if you choose to unilaterally seek self-help and violate an agreement or a court order or engage in any non-compliant behaviors. If you believe that there needs to be a modification to the court order, seek legal assistance to be able to bring forward a motion to change. And finally, what I tell my clients is to always maintain transparency, excuse me. So if one of you or my client is facing financial difficulties, inform us, inform the court, and seek a legal modification. That usually relates to child support or spousal support, but seek a legal modification to the agreement or the order rather than defaulting on payments. Because if you default on payments, you're responsible for interest, and it doesn't look good that you are not complying with the order.
Thank you so
Maybe just
much,
to connect
Joseph.
that, maybe just to
Yeah, go
connect
ahead.
to the topic of what we're discussing today, and that is what's the judicial system value in parents. And the appreciation is when a party comes to court with clean hands, it's always a better way to impress and show the respect to the judicial system. And you're not just coming to court to get your way, but rather showing that you have complied with the set agreement or with the order to the T, and therefore, if the other side is not complied or is intentionally decided not to provide the information that was required or to follow the order, it simply, you have the advantage of looking better in terms of your credibility, in terms of your appreciation and respect. And that's what I think the judicial system appreciates, that it's being respected, that the order is not a recommendation, it's an order. And that's the idea of the, everything that Joe says is correct in terms of many ways to enforce and compel another party to follow orders, but that's not the the essence of what we're trying to impress upon the listeners here is how they're going to be impressing the judge that they're going to come in front and try to lay their case and try to convince a judge that they're in the right and the other side is the is the one that needs a reprimand and or just need to be corrected in its behavior or her behavior. So
Mhm.
that's the idea of the legal system is there for a reason, because otherwise there's chaos. And that's the idea. The idea is that the appreciation is for those who come to court with clean hands, and then there's a reason why they should be also awarded the relief that they're seeking.
For sure. And the court does not appreciate unnecessary litigation, and ongoing litigation that just seems like it's a waste of time and court resources too, because for every time you go in, the court workers also need to be paid. So it's, it's needs to be a good use of everyone's time, because there are lots of families that need to appear before the court. And in on that vein, Golan, if you could just tell us more about the financial obligations, in terms of support, whether it be child support or spousal support, and individuals' responsibilities to maintain and manage those payments.
Yes, Joe. So again, this goes to what is being appreciated in parents' behavior when it comes to their financial obligation to one another. Coming to court when a financial arrangement have been made, and with or without legal advice. For example, if one parent has a primary care and the other parent have time with the child, and it's clear on the face of in the situation like that there is an obligation to pay child support, that arrangement has been made, legal advice been obtained perhaps as to what amount should be paid to the other spouse, and it's being done before you attend court. So it's not a situation where a child is suffering, the other spouse suffers, the economic pressure is not appreciated. So when you come to court, a few months later, and there still hasn't been any payments, and it just caused the financial hardship on the other parent or the children, it's not looking good, and it's not appreciated at all. That goes also to spousal support situation when it's clear on the face of the circumstances there that one parent is in need, and we generally speaking in this situation at the need aspect, that one parent perhaps has not been in the workforce and was totally dependent on the other parent financially, and you want to see that upon separation arrangement for the support has been made. Whether it's satisfactory or not, that can be determined at the latest stage, but there's got to be that obligation of support, whether it's the moral aspect or the legal aspect of it, has to be there even before the commencement of the proceedings. And that is what being appreciated. If you're asking me, when you go to court and you show that arrangement has already been made, and could be that the other party may not be happy with the arrangement, or that it's not satisfactory to a certain degree, that can be adjusted. But the general idea of not providing the financial obligation to the children or to the spouse is definitely not something that is looked favorably. And that goes along with the need to provide disclosure, at least at the level of the income verification, to determine what is the amount that should be paid for child support, and then maybe do a calculation for spousal support with the assistance of counsel. These things could be done prior to commencement of any proceedings, and maybe that would avoid proceedings altogether, because if there's no economic pressure, maybe there's ways to continue the negotiation and discuss the matter between the parties, with assistance of counsel is always suggested and recommended. but it could avoid the litigation altogether. So that is the aspect of financial obligation that's being appreciated by the court, is that you actually put your mind to meet your obligation to the children, to the spouse, and you made the reasonable efforts to meet those obligations, and provide the disclosure that is essential to even start looking at aspects such as financial support or equalization of net family property, which is often the case in married couples. But that's the idea, that you do that even prior to commencement of litigation, and during litigation, that the transparency, as was mentioned earlier, is there, that all the all the documentations that are required, whether it's for income verification, for business valuation, for getting the assets valuation, your statement of accounts, etc., and disclosure of any assets or debt that is existing, whether it's on date of marriage or date of separation. All of these are required as an ongoing obligation, financial obligation, that doing that and complying with that obligation definitely wins points to the party that follows the rules, in a sense, for transparency and acting reasonably and fairly in the proceedings.
Yeah, thank you, Golan. And yeah, on that note, well, to expand on that, that I think that the court just does not like to see lack of effort. Court wants to see effort, and effort in meeting obligations that will allow if you're going to pursue a legal proceeding, it will shorten it. It will make it less onerous on the parties and the court. And so, Joe, I'm just wondering if those kinds of considerations can extend to relationships between the parents in co-parenting. How does that look? What can parents do to co-parent well, and what will the court value?
Yeah, for sure. So I mean, with respects to, fostering a positive co-parenting relationship, the emphasis and the emphasis is high on that front, and courts are expecting that to occur on a daily basis. So, ultimately, courts favor parents who can work together for their child's benefit, point blank, period. Why? It minimizes stress and reduces emotional harm to the child, which they like to see. And at the same time, it also demonstrates, a parental maturity and responsibility, right? That's crucial in legal proceedings. Courts like to see that both parents, if they are engaged in the legal process, that there is a sense of maturity and responsibility, and that there's no frivolous or vexatious proceedings occurring, and that both parties are not on the same wavelength, in an effort to settle and to be reasonable. Ultimately, family court is different in the sense that it is crafted as a means for parents and parties to, amicably, or maybe not amicably, because I don't think that's necessarily the case always, but to at least be reasonable. If you're not going to be amicable, then courts expect you to be reasonable and to settle, right? That's the idea of the court process. There's so many different hearings that occur and stages of the court process that occur prior to a trial commencing. I have clients that come in the office saying, "Oh, like, when are we going to trial? Like, I want to go to trial in this," and they don't realize that it's 2 to 5 years down the road to trial, and that there's many appearances beforehand that are there so that the parties can work towards a settlement and be able to have those settlement discussions. But if you are maybe not in the right headspace, or you're not in the right environment, you may be in a toxic environment, and maybe not able to actually foster that positive co-parent relationship that the courts expect of you and that they favor. There's some ways in which that can occur, right? So primarily what I tell clients is that they should be keeping conversations child focused. So when you're communicating with your ex-spouse or your ex-partner, stick to parenting matters and avoid personal grievances. So that's number one. Again, using neutral professional language, of being able to avoid inflammatory remarks or accusatory language. There's a really great justice out in the Peterborough area, Justice McLeod, and always he puts forward the rules of separated parents whenever we attend a conference. And it's about a list of, I believe, 15 rules for parents that they should be engaged in during the litigation process. And it ranges from communication rules to behavioral rules, and these are all things that the judiciary hopes that parents will abide by. It's the rules of separated parents. We can put that as a show note for after, but I would take a look at that. As well, another communication strategies that judges also put forward in their favor, and I've already mentioned it in this webinar today, is to leverage co-parenting tools. So being able to use applications such as Our Family Wizard, Talking Parents, those are the two. I'm missing one. It's, app close, right? These are all ways in which parents can manage communications between one another, and they have schedules. So you both don't actually have to physically speak to one another, but these tools are there so you can make schedules. You can put when your child's doctor's appointment is. You can have all these things scheduled out, and it actually allows you to foster this co-parent relationship that judges favor, while not actually having to communicate with one another. It's a really great technology. And what judges absolutely despise, and I've already mentioned that today, is avoiding that aspect of parental alienation, right? So what is parental alienation? It's when one parent manipulates or influences a child to turn against the other parent, and that also can be extended to extended family as well, whether that's the paternal or maternal family members. Examples
So,
of which.
without interrupting,
Sorry, go ahead.
Without
Yeah, go ahead.
interrupting, because everything is absolutely important, especially in this area of co-parenting, and we probably can have a whole other session regarding that. I just want to mindful of the time for
100%.
For sure. For sure.
program. We want to make sure that that we can somehow conclude the matter in a positive note here. So I'll pass it on
For
to
sure.
you to wrap it up.
To wrap it up, okay, I can give us some final thoughts. The court really values parents who can adapt to changes without unnecessary conflict. So being flexible is really important. And being flexible doesn't mean giving in. It means recognizing that parenting requires adjustments. So just another tip to, be mindful that you can be flexible in this process. It's not about winning or losing. A child-centered approach definitely leads to better outcomes. I feel like this is what we've been saying throughout. And remember that flexibility and compromise isn't losing. It means creating a more sustainable arrangement that works for everyone involved, and particularly the child. So, Joe was diving into the deep end there with parental alienation, and that could be a whole topic all in itself. But right now, we just want to leave you with ensuring that your mindset towards this process and approach is child-centered and allows the children in the relationship to thrive. So yeah, today I will thank you for tuning in. I'm going to wrap up really quickly. For the following this session, there will be a brief survey that will appear and allow you to share your comments, suggestions for future topics. And so your feedback is also greatly appreciated. About that opportunity I mentioned earlier, if you want to book a complimentary consultation with one of our lawyers, please contact our intake team at to schedule your appointment. We look forward to seeing you next time. That topic will be how to bond with your child during divorce. So thank you once again. You can go to russellalexander.com /family law now to sign up for that the next session. And yeah, thank you so much to Golan. Thank you to Joseph.
Thank you,
Wealth of
Joe.
knowledge.
Thank you,
Thank you,
And
guys.
look at that,
Joe.
6 o'clock.
There you go.
Thanks,
Good job.
everyone, for your
All right.
time.